Hello, and welcome to this webinar on NAMB's proposed Nursing Act. In this webinar, we will speak about the proposed legislation that will address nursing regulation in New Brunswick for years to come. I'm Kate Shepard, CEO and Registrar of NAMB, and in the webinar, I'll be presenting with my colleague Colin Leahy, NAMB's Director of Policy Risk and Compliance. Our agenda for the webinar is to highlight the key subjects covered by the proposed legislation. We hope that this overview will support you in providing feedback that will be considered before the Act is finalized. We will not be addressing all elements of the proposed Act and legislation, but a copy of the Act, bylaws, and summary of the legislation, as well as FAQs, are all available on our website, and we encourage you to review those. The current Act was proclaimed in 1984. Since that time, the nursing profession has changed considerably. Roles have changed and continue to expand. As such, the legislation needs to reflect those changes. With increasing demands and insufficient resources in the healthcare system, there is a need to have flexible legislation that reduces barriers to practice and makes entry to practice as efficient as possible, while at the same time ensuring that New Brunswickers will continue to receive nursing services from competent and qualified nurses. While the nursing profession and healthcare have changed, so too has the regulatory landscape for health professionals. Across Canada, many reviews have been conducted in response to concerns raised by the public and governments about how regulators go about their work. The conclusion from these reviews is that regulators must focus on the public interest, and their legislation must make that clear. Finally, the members of the nursing profession must also be satisfied that the processes used by their regulator reflect best practice and are fair, efficient, and that must be reflected in the legislation. As a result of these developments, we have seen many provinces, such as PEI, Nova Scotia, British Columbia, Alberta, all update their legislation. The team at NAMB has been working for the past 3 years on developing this proposed legislation. Throughout the process, we have been guided by information from other jurisdictions to understand the current legislative approaches and adopted those approaches to fit the needs of New Brunswickers. 3 key principles guided the proposed Act. As I mentioned, governments and regulators across the country have engaged in reviews of their nursing legislation in response to concerns raised by members of the public and governments. Many of those concerns are grounded in the belief that regulators protect their members and focus on membership interests rather than focusing on the public interest. A key recommendation from this legislation is that the legislation must be structured to put the interest of the public first. This is demonstrated through more public transparency and accountability. Another principle that was used in development of the proposed Act is that of enabling language. It is critical to have an Act that will withstand the future changes in the profession and the healthcare system. This is demonstrated by the use of language that allows for flexibility and adaptability. For example, when we consider scopes of practice, we have set out scope broadly and then have added language to indicate that additional aspects of scope can be addressed through the bylaws. So the legislation does not limit by setting out prescribed lists, but uses language that allows for flexibility and change. A third important feature of the legislation is that we have strived to simplify processes for registration and complaints. We have sought to reach the balance of efficiency, fairness, and public protection. I'd like to take a moment to talk about our professional association work. Many organizations have a role in nursing. Nursing regulators have the unique role of protecting the public by regulating nursing professionals and nursing education. Generally speaking, regulators do this by promoting good practice, preventing poor nursing practice, and intervening when practice is unacceptable. This is a distinct role from nurses' unions and nursing associations. Each has an important role to play in the nursing profession. Nursing associations, such as the Canadian Nursing Association, focuses on advocacy for the nursing profession. Unions focus on the interest of the members, such as work-life balance, social, economic, and personal well-being. We are changing to ground ourselves in the role of a regulator and its mandate of public protection. But NAMB does value the importance of advocacy for the profession and healthcare advocacy and is working closely with a group of interested individuals to support the formation of a New Brunswick Nursing Association. And NAMB has previously announced that it has set aside funding to support its development. In legislative language, the purpose of the college is called its objects. This is an important part of the Act, as it makes it clear that the college's purpose is to serve and protect the public interest by doing various things. The list of what the college can do always has to be read in the context of the opening language that it is doing all of its functions in order to serve and protect the public interest. The list of functions that are on the slide is a partial list, as the Act goes on to include other functions of the college, and we encourage you to review the full content of Section 4 of the Act. In this section, you'll find elements such as establishing, adopting, enforcing a code of ethics, standards of practice, entry-level competencies, criteria for registration and licensing, and approving nursing education programs, and the criteria for the continuing competence program. In the proposed Act, we have proposed terminology and structural changes. These changes align with those made by other nursing regulators in recent years, including changing our name from an association to a college and changing the use of the term member to registrant. These changes function to create the distinction between a regulatory body and a membership organization. We've also proposed changing the name from Nurses Act to Nursing Act. And here, we are signaling that this legislation is about more than nurses. It also includes elements of nursing practice, nursing education, and applicants who are not yet nurses. With respect to how the legislation is structured, the Act is the key piece that sets out the basis for all the actions that the college can undertake. The Act indicates that details about various matters, such as the composition of the board, will be set out in the bylaws. In addition to the Act and the bylaws, there is also the authority to develop policies on certain matters. And again, this is an example of application of the key principle of enabling language. The Act, Section 8, speaks to the bylaws. All bylaw changes, so new bylaws, removal of a bylaw, or amendments to a bylaw, require that a copy be sent to all registrants, followed by a 30-day period of consultation. In addition, some bylaw changes do require the Minister of Health to approve, for example, changes to scope or designations of nurses that we would regulate. Next, we will talk about governance and scope of practice.
As in any regulatory organization, it is critical to have a clear understanding of which roles lie with the board, the CEO, and the registrants. Under the proposed legislation, the board is the overall governing body. When we speak of governance, we are speaking of the oversight role of the board over the CEO, the type of insight the board needs to have to govern effectively, and the type of foresight the board needs to exercise to provide strategic direction to those who are operating the college, that is, the CEO and staff. The CEO role is the key managerial role of the college, and the CEO is the sole employee of the board, who, together with the staff hired by the CEO, run the operations of the college. The CEO is given the authority under the Act to delegate functions, So where you see in the Act, for example, that the CEO must approve registration applications when various criteria are met, it's not the actual CEO doing the approval, but staff to whom this function has been delegated. The registrants of the college play a large role in regulation by serving on the college's regulatory committees and on its board of directors. To provide some continuity, the board in existence at the time the new act comes into force will be the first board under the new act. Within 1 year, a new board will be appointed. The bylaws will set out the detail of that process, and the bylaws will be sent out for consultation before they are approved. So you could expect to see those new bylaws that will address the composition of the new board within the first year of the college being established. The Act sets out that the minimum number on the board will be 7 and the maximum will be 13, and whatever that number may be will be established in the bylaws. Of that number, the bylaws will also establish what percentage must be public representatives, individuals who are not nurses, but that number must be at least 1/3 of the board and not more than 1/2. These changes reflect the direction taken by governments in other jurisdictions where best governance practices show a trend towards smaller boards with greater public representation.
The next few slides are specific to scope of practice. The slides are full, but scope is a central piece of the new legislation. To inform us on scope, we completed jurisdictional and literature reviews. We ended up with scopes of RN and NP practice that are defined in more detail, provide clarity, and enable practice to full and future scopes. It's designed to reflect current practice as well as allow for future flexibility by allowing evolution through the bylaws. Such bylaws would require ministerial approval. You can review Section 10 of the Act for full details on RN scope. But as you can see on the slide, we have defined RN scope as the application of skill, judgment, evidence-based knowledge of nursing theory, health, human sciences, and the provision of nursing services to clients ranging from stable or predictable to unstable or unpredictable, and includes elements such as assessing, planning, developing, implementing, monitoring, evaluating, coordinating care, and collaborating, as well as supporting client safety and quality care, and those roles such as research, education, consultation, management, administration, policy development, and regulation. And then again, an example of that enabling language, there is a statement including other roles as outlined in the bylaws. Now, moving to NP scope, we have defined NP scope as in addition to the scope of the RN. So it starts with that foundation and then adds more from there. NP scope can be found in full in Section 11 of the Act. So as on the slide, NP scope is in addition to the scope of practice of registered nurses and includes the application of advanced nursing knowledge, skill, and judgment. NP scope is inclusive but not limited to making diagnosis, identifying disease, disorder, or conditions, communicating a diagnosis, performing procedures for clinical management and prevention of disease, injury, disorders, or conditions, prescribing, authorizing, ordering, administering, and dispensing drugs and medications, as well as initiating, ordering, prescribing consultations, referrals, medical devices, treatments, and includes the application of forms of energy and other non-pharmacological interventions. It continues on to ordering and receiving and interpreting screening and diagnostic tests, selecting and recommending, prescribing, or ordering blood and blood products, specifically permits admitting and discharging clients from hospitals, institutions, and programs. And again, in keeping with the RN, other such roles such as research, education, consultation, management, administration, policy development, and regulation. And again, that use of enabling language in relation to other services and activities as set out in the bylaws. There are currently restraints or constrictions on NP practice, such as the requirement for the NP Nursing Therapeutic Committee, which recommends specific screening and diagnostic tests, drugs, and forms of energy that the NP can order. The current Act also stipulates that the NP must have a consultative physician on file. Under the new Act, these constraints have been removed. It is important to note, however, that NPs still must act within their individual scope of practice, within their standards of practice, within practice guidelines, and must continue meeting continuing competence requirements. The proposed legislation also introduces the concept of expanded scope. This opens the door for the board to list certain expanded RN practices if that RN has the appropriate education. The best example is RN prescribing, which exists in other provinces where RNs who have taken approved prescribed education are permitted to prescribe certain types of medications. The RN who is approved to engage in prescribing would be publicly available on the college's website so the public, including employers, will know who has this additional expanded scope. For more information on expanded scope, please refer to Section 12 of the Act and Part 11 of the bylaws. We will now be moving on to registration and licensing.
We often hear the terms registration and licensing used interchangeably. However, there are two separate processes to go through for each. The new Act clarifies that the first time an applicant seeks to become registered, they go through a registration process, and after that, on an annual basis, the registrant seeks to meet yearly licensing criteria. We will speak about the criteria for both registration and licensing in a few moments, but it's important to note that there is a waiver provision in the proposed legislation for these. So sometimes, through no fault of an applicant, they are unable to meet the formal criteria. For example, internationally educated nurses from war-torn countries may not be able to produce formal documents from regulators in their countries that may be required for registration. The Act provides the CEO with the ability to waive requirements as long as the CEO can be satisfied there is no risk to the public in doing so. Also, we know that the Canadian Free Trade Agreement requires nurses licensed in one Canadian province to be licensed with the same kind of license in New Brunswick. If that nurse does not meet one of the formal criteria, but holds a license in another province, the college will be required to waive the formal criteria to be compliant with the Free Trade Agreement. So we're going to talk about the process for registration, licensing, or renewal of licensure. So once received by the CEO, the application can go one of four ways. It can be approved. We are going to go down a bit of a rabbit hole here because, of course, to be approved, they must meet all the requirements. So we're going to list those requirements for registration and licensure before we carry on with the other possible outcomes of an application. So the requirements for registration are the payment of the applicable fee and form. I say applicable because depending on the designation, forms and fees could vary. An NP application will ask for different information than an RN application, for example. Then we have language proficiency. So of course, in New Brunswick, applicants for registration need to demonstrate language proficiency in either English or French. Exams. So we're talking here not only about entry to practice exams, but also exams such as the jurisprudence exam, which is a registration requirement. Proof of competence and good character. So that can be demonstrated in a few ways. We do ask applicants for registration to provide us with criminal record checks. And for any educators listening, we do have a process for new grads whereby approved programs send us lists annually of graduates stating that each grad has completed an approved nursing education program and that they are recommended for registration. Finally, what's really important to mention here is the capacity requirement. So we're speaking here of fitness to practice. Under our current legislation, CNNB is not Under our current legislation, capacity is not a registration requirement, and the only real method that CNNB has to deal with issues of capacity is to let someone register, if they meet all the other requirements, of course, and then deal with the issue through the complaints process. The proposed legislation makes capacity a requirement for registration. The requirements for licensure are similar to the requirements for registration, but I do want to point out a few key differences. So we have exams here as well. But of course, we aren't going to ask registrants to pass the entry to practice examination every year. We're talking here about examinations that could be made mandatory for licensure renewal, for example. For the last few years, we've had mandatory learning modules, which have an exam component, but perhaps a better example that you might remember from a few years ago is in 2020 when the jurisprudence exam became a registration requirement. It was also a mandatory licensure requirement that same year, so all registrants had to complete the exam in order to renew their license to practice. Then we have the continuing competency requirement. So in order to renew their registration, registrants must complete their CCP in order to renew. And then finally, we have currency requirements or hours of practice, which we'll talk about in a little bit more detail because the proposed legislation does change those requirements from what they currently are. So the new proposed currency requirement better aligns with our closest jurisdictional neighbors and lives in the bylaws. So again, when things live in the bylaws, we have the ability to update and change them more nimbly to be able to respond to emerging trends in regulation. So the new proposed currency requirement for both RNs and NPs is 450 hours in the previous 3 years. The 450 hours for NPs need to be clinical hours. The reason for that is that what truly differentiates an NP's practice from that of an RN is diagnosing, prescribing, ordering tests, etc. And those are things that happen in the clinical setting. So although the scope of NP practice in the proposed legislation is expanded to include other NP roles other than the clinician, for the purposes of currency, the 450 hours need to be clinical hours. And so carrying on, so we are finally back to our graphic here. So an application can be approved if it demonstrates that an applicant meets all of those requirements that we just went over. It can also be denied. It can be approved with conditions or restrictions, or it can be referred to the Registration and Licensing Committee. So that fourth bubble, that referral to the Registration and Licensing Committee, is really the key difference between the current state and what's being proposed. So if an application for registration is denied, or conditions or restrictions imposed, an applicant who wishes to appeal that decision or have it reviewed can appeal it to the Registration and Licensing Committee. The CEO can also refer a matter if it's particularly complicated, for example. The committee can then approve the application, deny the application, or approve the application with conditions or restrictions. But it doesn't necessarily stop there, because once again, if the applicant is dissatisfied with a denial or with the imposed conditions or restrictions, they can appeal to have that decision reviewed by the Registration and Licensing Review Tribunal. So those two committees, or a committee and tribunal, would be new, and they create a huge difference from the status quo, because currently anyone who is dissatisfied with the registration-related decision only has the option to appeal to the board of directors. And just to note that the composition of those Gs is set out in the bylaws, so bylaw 14.1, which states that the committees shall include one public representative, 2 RNs, and 2 NPs.
We will now be moving into the topic of investigations and hearings. The changes to the investigation and hearing section of the proposed act are about flexibility and options for resolution, thus allowing for more efficient processes. They also modernize the language to move away from words like discipline and guilty. The proposed act allows for more efficient resolution as it provides for more options to the CEO and the committee to resolve. We've also changed the committee names, indicating that a tribunal is a decision-making body. It's also introduced a fitness to practice process. Where matters involve health issues, there is a dedicated option to take a remedial approach through fitness to practice processes. It also describes that the complainant is not a party to the process, but rather acts as a witness. So the parties to a complaint would be the college and the nurse. The college still has the authority to deal with 4 main matters: professional misconduct, which involves conduct in the practice of nursing; conduct unbecoming, which refers to conduct outside of the nursing practice in a registrant's personal or private capacity that can be reasonably seen to bring discredit upon registrants or the profession; incompetence, which refers to lack of knowledge, skill, or judgment that renders the nurse unsafe to practice; and incapacity, which refers to the registrant's physical or mental condition or disorder that impairs their ability to practice in a safe and competent manner. These definitions have been reformulated to align with other nursing legislation in other Canadian jurisdictions. The Act also makes it clear that the College can act on receipt of a complaint from the public, registrant, or anyone, but also has the ability to initiate a complaint if it receives information that suggests it should do so. Sometimes an individual does not wish to file a formal complaint, but may give information to the College, or the College may become aware of an issue through other regulatory processes like licensing renewal. So in those situations, the CEO and the committees have the ability to take that reported information and turn it into a complaint. It is important that the legislation spell out the specific rights of the nurse who is subject to a complaint. This also demonstrates the key principle of registrants having fair processes available to them. The nurse who is subject to a complaint has the right to legal representation, the right to receive notice of any matter under investigation, an opportunity to respond and make a submission. It also has the right to that principle of natural justice. Natural justice is a legal term for procedural fairness taken from the law in the court in making their laws also applicable. The nurse also has the right to other information as determined by the CEO.
So now I'm going to briefly walk you through the intake and investigations process. As you can see in the first bubble here, the process is set in motion when a complaint or report is received. However, it's important to note the College can also act on any information it receives throughout any regulatory process to initiate the investigations process. Another key difference is the smaller bubble just below and to the right of that one here that says limited authority of CEO to address complaints. So upon receipt of a complaint, the CEO has the ability to dismiss the complaint, provide advice, informally resolve the complaint, authorize the resignation of the respondent, refer the respondent to the fitness to practice process, refer the complaint to the Complaints and Investigations Committee, begin an investigation, or, with the consent of the registrant, arrange a health assessment, practice audit, or review, or competence assessment. This authority given to the CEO is meant to expedite the ability of the College to address complaints. It must, however, be noted that the CEO does not have the authority to issue licensing sanctions, which is the term used for things like reprimands, suspensions, or revocations of licenses, the more serious consequences of the complaints process. The big middle bubble with the magnifying glass represents the stage at which the CIC, or the Complaints Investigation Committee, would meet, either following an investigation or after a referral by the CEO. The possible outcomes of these meetings are as follows. The complaint could be dismissed. It could be informally resolved. The committee could provide advice to the respondent. They could issue a caution to the respondent. They would require the respondent to complete a specified continuing education or remediation program, also referred to as a SCRP. Or they could refer the complaint to the fitness to practice process, or finally refer to the professional conduct tribunal. This smaller bubble on the bottom of the slide represents the fitness to practice process, which is an alternative to the traditional disciplinary process. It addresses issues of incapacity. So where the CEO, the Complaints Investigation Committee, or the Professional Conduct Tribunal suspects incapacity, they may order an assessment and determine if a person is eligible for the fitness to practice process. If not eligible, they may consider options like initiating a complaint. So before moving on from the investigations and hearings sections, we will briefly touch upon the Professional Conduct Tribunal process. So following a referral by the Complaints Investigation Committee, any pre-hearing conferences and/or motions, the Professional Conduct Tribunal will hold a hearing, the possible results of which are as follows. The PCT could order a revocation of the respondent's license, a suspension of the respondent's license. They can order that conditions and/or restrictions be imposed on the license of the respondent. They can reprimand the respondent, they can fine the respondent, or they can order costs against the respondent. They can also, and this time without the consent of the registrant, order any medical examinations, practice audits, and competence assessments, or refer to the Fitness to Practice Committee.
Unfortunately, reports of sexual abuse do come forward. To address this, in 1996, the government of New Brunswick imposed requirements on all health regulators around sexual abuse. The proposed act goes further and better aligns with societal expectations. The act has added inappropriate sexual activity between nurses and clients, but also between nurses and others, for example, students. Sexual abuse is specific to client, and sexual misconduct is specific to others. The proposed act also introduces mandatory sanctions, including revocation of licensure for more serious cases. And this is signaling to the public that we take sexual abuse seriously and provide the tools to manage those cases. These provisions follow similar changes made in nursing legislation across the country. We will now move on to duties to report and title protection. The current Act speaks to duty to report where there is reason to believe another nurse is unable to function safely to such a degree or extent that it is in the best interest of the public that the other nurse no longer be permitted to practice or that practice be restricted. In addition, the proposed Act refers to a new duty to report other regulated health professionals in addition to reporting nurses, and adds language to better define circumstances which require reporting, and outlines these clearly. They are physical abuse, emotional abuse, financial abuse, sexual misconduct, any act of professional misconduct, incompetence, or conduct unbecoming of the profession, or that the nurse or other regulated health professional are or have been engaging in conduct that poses a danger to client safety. Again, this is an example of the focus on public protection, as well as having more simplified and clear processes for registrants. Employers also have duties. The current Act does speak to the duty for employers to ensure that the nurse has current registration and that the nurse is not engaging in any duties contrary to any existing condition on their registration, as well as a duty to report if a nurse is terminated due to incompetence or incapacity. The new proposed Act expands on these duties, as noted on the slide, to acts of physical abuse, emotional abuse, financial abuse, sexual misconduct, any act of professional misconduct, incompetence, or conduct unbecoming of the professional, or is or has been engaged in conduct that poses a danger to client safety, as well as expanding on the duty to report on suspensions and terminations, indicating the employer needs to report to the college where they have suspended or terminates or limits employment for misconduct, conduct unbecoming, incompetence, or incapacity, or that the registrant resigns or departs their position for any of these reasons. These expanded duties to report reflect the need to emphasize public protection, and these can be further reviewed in section 126. The proposed Act sets out titles that are protected. Those include registered nurse, RN, nurse practitioner, NP, graduate nurse practitioner, GN, GNP, and the term nurse. This is not a change from the current Act. The Act makes it clear that only those who are licensed or authorized by the proposed Act can engage in the practice of nursing unless they are considered exempt. This, for example, includes LPNs. LPNs engaging in nursing practice can call themselves an LPN, or students who are enrolled in an approved nursing education program, or families learning to provide nursing care. For more information on title and practice protection, that can be found in Section 42 of the Act and 43. Up next is a section on confidentiality and privilege and reporting and accountability.
Now I'm going to address confidentiality and privilege. So confidentiality is, as the name implies, an obligation to maintain the confidentiality of information that's in the possession of the college. The current legislation is silent on this issue of confidentiality. But because the college will obtain information that has a lot of sensitivity, personal health information, for example, we wanted to ensure that there were statutory requirements to protect that information. So the proposed legislation requires all information from any regulatory process, and that might be registration, licensing, investigations, hearings, etc., must be held confidential by all college representatives unless there are exemptions. And those exemptions are: we're authorized by the Act to disclose information, where there is a need to provide information to another regulatory body, where there is an exemption that legal counsel may have access to confidential information, where information is otherwise publicly available, where disclosure is required by law, or where disclosure is in connection with the administration of the Act. So that's confidentiality. Privilege is a different concept from confidentiality. What we mean by that term in this context is information that comes into the hands of the college for any of its regulatory processes cannot be used outside of the college's processes for another purpose. Probably the best illustration of that is when there's a complaint, the college may commission an expert report to determine whether the particular acts of the nurse met or did not meet expected standards of practice. So if there's an expert report involved, that expert has been retained by the college for the college's purpose. That expert doesn't want their opinion being used if a patient files a civil lawsuit, for example. So this concept of privilege protects the information obtained by the college and prohibits its use outside of college proceedings. So that's a really important addition to encourage participation in the college's processes without fear that information is going to be used in external legal processes.
There are new provisions in the proposed Act in relationship to reporting and accountability compared with the current legislation. These reporting requirements are consistent with a greater focus on regulating in the public interest. These include requirements with respect to reporting to the Minister of Health, but also, in addition, there is a new requirement to publish records of board meetings. This degree of transparency is important to provide information to both the public and registrants about the work of the board. Since it is anticipated that board members be appointed rather than elected in the future, this requirement to keep registrants and public informed of what is happening at the board provides an important accountability mechanism. More information on this can be found in Section 9 of the Act. In addition, there is a requirement to publish specific information on the college's website. This would include the name, registration number, licensing category, and status of nurses. This serves to assist the public when identifying nurses who have provided nursing services to them, which assists them when filing complaints. The Act does require publication of the nurse's place of practice, but then specifically states that if that is also the nurse's home address, it is not required. There's also provision that the CEO can refuse any aspect of publication where deemed that there is a safety or other reason to not publish that information. This can be found in Section 14 of the proposed Act. Moving on to next steps. The consultation process is ongoing now until the end of May. We hope that this webinar has supported your understanding. And please note that there are a number of additional resources available on the NANB webpage, including a summary document, an FAQ document, as well as full copies of the proposed act and proposed bylaws. Once the consultation period has concluded, NANB staff will collect and organize all the feedback and then share with the NANB Board of Directors for their consideration. After that, we will begin our work with the government of New Brunswick to review and then introduction into the legislation. In conclusion, there is lots of work ahead, and feedback on the draft is valuable and important. To submit your feedback to us, please visit the NANB webpage, and you'll find the relevant documents, as previously noted, as well as a survey for completion. The survey takes approximately 30 minutes to complete, and there is a save and resume option available for those who cannot complete the survey in one sitting. Or additionally, you can email your comments to us at nanb@nanb.nb.ca.